So good afternoon, everyone, and welcome to the first environmental quarterly updates from FDB for the year 2022. So Happy New Year to everyone, and we're all hoping, of course, for a safe and healthy year for everyone. And this session we have today takes in a range of very topical subjects, including, we're going to start in a moment with Flora's update on where we are with COP26, which, as you know, took place at the end of last year. We're going to touch on a number of important environmental subjects this afternoon. The timetable is to start now. We go to Flora, as I said, who will take us into COP26. And then Richard Honey, Queen's Counsel, and Merrow Golden will do a double act on climate change litigation. And then we'll have a short comfort break of 5 minutes before we then turn to Ned Westaway, who's going to give us a short update on various issues on air quality, before we end with David Graham, who is going to be talking on aspects of the recently passed last year Environment Act. There'll be an opportunity for questions, and if you can put them in the note session, that's great. And we will endeavour to do our best to answer them. And then we'll finish thereafter. I'm afraid, for all sorts of reasons, there won't be any drinks being offered. This is certainly not a party, but I hope you'll enjoy the next couple of hours and find them useful. So I'm going to turn then to Flora, who is one of our rising stars in Chambers. Flora was a pupil of mine as well as others. So all of her great qualities, you'll see, she's learnt none of them from me, and she's learnt them from her other more distinguished pupil supervisors. She's going to brief us on where we actually finished up in COP26. And Flora's got already a wide experience of not only planning, but particularly environmental law and environmental law policy. So Flora, over to you now to begin us with what happened at the end of the year with COP26.
Thanks, Greg. I will just share my slides, which hopefully can now be seen by everyone. So yes, I'm going to be speaking about COP26 and the Glasgow Climate Pact, and effectively what was agreed and what came out of the COP26. So just as an overview, starting with the obvious question, what was COP26? It was the 26th conference of the parties to the UN Framework Convention on Climate Change of 1992. The conferences act as a monitoring body for that convention. The aim of the 1992 convention being to take climate change considerations into account in social, economic and environmental policies. And there are annual conferences of the parties to help achieve this. Previous conferences were variable in their outcomes. One of the most recent landmark agreements coming at COP21 in 2015, which was obviously the Paris Agreement. Paris set a long-term temperature goal to reduce emissions to well below 2 degrees centigrade above pre-industrial levels by 2100, as is well known, and also to pursue a 1.5 degree limit in the same time period. It placed obligations on parties to report on the contributions that they would be making to help achieve these goals, with specific focus being on adaptation to climate change, mitigation and finance. Coming into COP26, the expectations were high. There'd been a 2-year gap since COP25 in Madrid, that delay being due to the pandemic. And at the time that COP26 happened, there was an increasing feeling among world leaders and populations that we're running out of time to deal with climate change and to meet the Paris temperature goals. Earlier in the year, the Intergovernmental Panel on Climate Change had highlighted widespread, rapid and intensifying effects of climate change, leading to the UN Secretary General issuing the Code Red for Humanity. The urgency that was felt going into the conference was reflected in many of the speeches that were made by world leaders at the opening of the conference. Boris Johnson, for example, described the world as being at 1 minute to midnight on the doomsday clock. And Mia Mottley, Prime Minister of Barbados, described the climate crisis as an existential threat for small island nations like Barbados, saying that a 2 degrees rise by 2100 would effectively be a death sentence for those living in small island nations. So there was a lot of pressure on world leader and delegates to deliver at COP26 and to take concrete steps to ensure that the Paris temperature goals don't become unattainable. So what was actually achieved at the conference? Many agreements were reached, the central agreement being the Glasgow Climate Pact. So I'm going to discuss the Climate Pact and some of the other agreements that were reached and whether or not those agreements represent a success or failure reflected against the expectations going into the conference, and also what might some of the implications be domestically. So what came out of the agreement? The biggest agreement was the Glasgow Climate Pact. The parties also completed the Paris Rulebook, which is the rulebook essentially setting out guidelines for implementation of the Paris Agreement. And there were numerous other bilateral and multilateral agreements reached at Glasgow. So starting with the Climate Pact itself, it's been described as a single pact. It's contained within 3 agreement documents. It was signed almost 24 hours after the conference was meant to finish, with key pledges which will hopefully assist parties to deliver on the Paris Agreement. And I'll be talking about agreements in the 5 areas set out on the slide. So science, urgency and the temperature goals, coal and fossil fuels, parties' nationally determined contributions, adaptation and finance, and finally loss and damage. So in terms of science, urgency and the temperature goals, the way that the temperature goals and the work of the IPCC are discussed in the Glasgow Pact are a marked shift in tone from previous COPs. The Paris goal is obviously to limit temperature rises to well below 2 degrees and to pursue efforts to limit to 1.5 degrees. There had been unsuccessful efforts at previous conferences to strengthen the commitment to reach 1.5 degrees. At COP24, for example, there had been proposals to endorse the IPCC special report on 1.5 degrees and also to call on world leaders to act immediately to limit warming to 1.5 degrees, but that was blocked by the USA, Russia, Saudi Arabia and Kuwait. So the Glasgow Pact, and I've set out some of the text on the screen, does represent a shift in tone from that previous approach. It was opposed by some parties as effectively reopening the temperature goals achieved in the Paris Agreement, but ultimately was agreed. What the Pact does is it welcomes the 6th assessment report of the IPCC and also invites the IPCC to present its further reports to the subsidiary body for scientific and technological advice. So that represents a willingness to accept the IPCC's scientific analysis, so a shift from that earlier position. It also stresses the urgency and ambition that's needed over the coming decade. And it also affirms the 1.5 goal in Paris, making a number of statements strengthening states' commitment to reaching 1.5 degrees and not just well below 2 degrees. The Pact recognises that the impacts of climate change will be much lower at 1.5 degrees than in 2 degrees. It resolves to pursue efforts to limit to 1.5 degrees, recognising that limiting rises to 1.5 degrees will require rapid, deep and sustained reductions in greenhouse gas emissions, and recognises that accelerated action will be needed by 2030. So in effect, this is something of a recognition that that reaching below 2 degrees might not be enough, and that the direction of travel intended by the parties to the Paris Agreement is very much towards 1.5 degrees. Moving on to the nationally determined contributions. Under the Paris Agreement, parties are required to submit NDCs which outline the steps that they will be taking to reduce national emissions and to adapt to climate change. Last year was the first time that NDCs were required under the Paris Agreement, and at present 194 parties have submitted their first NDCs, with 13 parties submitting their second NDCs. The Paris Agreement itself doesn't require a second round of NDCs to occur until 2025, which will cover the period up to 2035. At the beginning of the conference, though, there were estimates by numerous bodies, including the IEA, that the NDCs submitted by the opening of the conference would still lead to a rise in global temperatures of above 2 degrees, which, while progress from the 3 to 4 degree rise that was estimated when the Paris Agreement was signed, is still doesn't meet the Paris temperature goals. So interestingly, the Glasgow Climate Pact invites parties to revisit and strengthen the NDCs that they've already submitted before COP27 in 2022. So it indicates that although the Paris Agreement doesn't require another round of NDCs until 2025, there is scope for parties to reopen the NDCs submitted within that 5-year gap and to raise their ambitions. Obviously, there's no requirement for them to do so under the Paris Agreement, but it's interesting in that it treats the NDCs as not necessarily being fixed. But ultimately, though, the way that this is phrased in the Glasgow Pact is just an invitation as opposed to a binding requirement. And numerous parties have already come out and said that effectively they will be treating their NDCs as fixed and they won't be revisiting them, such as Australia, New Zealand, and EU. So whether or not parties actually reopen the commitments that they've made remains to be seen, probably in the lead up to COP27. Another interesting commitment that arose in the Glasgow Pact relates to coal and fossil fuels. So you can see here on the slide, it's the longer paragraph at the bottom. This is what parties have actually agreed to, and it's highlighted. Parties have agreed to accelerate efforts toward the phase down of unabated coal power and the phase out of inefficient fossil fuel subsidies. Many nations were disappointed in the change from the original text. The original version is also set out on the slide and was much simpler. It simply called upon parties to accelerate the phasing out of coal and subsidies for fossil fuels. And as you can see, that commitment has been embedded in a broader commitment, and the wording of phasing out of coal has been replaced with a phase down of unabated coal power. And instead of phasing out subsidies for fossil fuels, it's now phasing out inefficient fossil fuel subsidies, which hasn't been defined itself in the agreement. Major coal exporters actually had accepted the original wording, including Australia, Indonesia, and Colombia. And the change came in a slightly dramatic fashion on the floor of the conference at the last minute by India's Environment Minister. And ultimately, it seems like in the interest of time and to secure the agreement as a whole, there was an agreement to change the wording to a phase down of coal power as opposed to a phase out of coal. Many have been disappointed in the change and the addition of phase down and efficiency, but it does represent the first time that a COP agreement actually directly refers to either the phasing down or the phasing out of fossil fuels. So it's an important symbolic shift, particularly when you consider again COP24, the then Trump delegation was promoting clean coal as an apparent solution to climate change, and now there's been a commitment by all parties to the phasing down of coal. Also, the agreement, the pact doesn't expressly refer to the phasing out of or phasing down of oil or natural gas, but generally it's been accepted by bodies such as the IPCC and the IEA that coal is the dirtiest fossil fuel for which most rapid cuts are needed to meet net zero targets and the Paris Agreement. Outside the pact itself as well, 23 countries did pledge to phase out coal power in a separate agreement, including 5 of the world's top 20 coal power using countries. So it does represent a step in the right direction. So adaptation and finance. Adaptation to climate change is obviously one of the key pillars of the Paris Agreement, but it's often overshadowed by mitigation efforts and emissions cuts. But as the real world effects of climate change are increasingly being seen, it's obviously particularly important, especially in developing countries. And at COP26, there was a renewed focus on adaptation. The Glasgow Pact acknowledges financial pledges that were made by parties in the lead up to and during the conference. Parties pledged over $350 million to the Adaptation Fund, which is a fund which was created in 2001 under the Kyoto Protocol. It has a mandate to finance adaptation projects in developing countries that are particularly vulnerable to the impacts of climate change. And that amount that was raised is the most that's ever been raised annually for the Adaptation Fund, and is almost triple the fund's mobilization goal for 2021. Countries also revisited the pledge that had been made at COP15 in 2009 to provide $100 billion annually by 2020 to assist developing countries in pursuing adaptation and mitigation efforts. That target hasn't been met. By 2019, countries were only providing $80 billion annually. The Glasgow Pact acknowledges this failure and expresses deep regret, and also urges countries to meet the target through to 2025. Whether that can really be considered a success of the conference is questionable, because it's ultimately reflective of a failure to meet a target that was set over a decade ago. Outside the pact, there's also been an agreement to establish the 2-year Glasgow Sharm el-Sheikh work programme on adaptation, with objectives to enable implementation of the Paris adaptation goals and enhance understanding of adaptation, and also contribute to reviewing progress on adaptation. Finally, in respect of the Glasgow Climate Pact itself, the pact recognised in its text the concept of loss and damage. Effects of climate change are becoming increasingly tangible and evident in countries more vulnerable to those effects. And so there has been discussion of how are parties going to ensure that loss and damage that's caused by climate change is addressed. Small island nations and other vulnerable states had during the conference sought a more formalized mechanism for funding to be provided to countries who are suffering from loss and damage caused by climate emergencies. This wasn't agreed to in the Glasgow Climate Pact itself, but the pact does acknowledge the existence of loss and damage, and it reiterates the need to scale up support for countries experiencing damage. The parties also in the Climate Pact agreed to fund the Santiago network, which is an existing network which provides assistance to states seeking to minimize, avert, and address loss and damage associated with climate change. Other agreements that were reached during the conference outside the central pact itself, one important achievement was that the Paris Rulebook was completed, which sets out the guidelines on how the Paris Agreement is to be implemented. It was expected when the Paris Agreement was completed that this would take 3 years to complete, but ultimately it's taken 6 years. Parties at COP24 had adopted an incomplete version of the Rulebook, but it has now been finalised. And the additions that have been added to the Rulebook, importantly in Article 6, clarification on mechanisms for the trading of emissions reductions and removals. So the Article 6 sets out clear rules to avoid double counting of carbon units. So it makes clear that where a country sells a carbon unit, it has to make an addition to its emissions levels in its emissions reporting. And where a country buys a carbon unit, it has to make a corresponding reduction. So that helps to ensure basically that we're not double counting carbon units when they've actually been traded by nations. Article 13 on transparency also clarifies the standard methodologies by which parties are going to report their progress on emissions reductions. And there's a new biennial transparency report, which has been agreed. Numerous other agreements have been reached, notably, for example, the methane pledge, over 100 countries agreeing to reduce methane emissions, and a US-China bilateral agreement. While China hadn't signed up to the methane pledge, the agreement with the US does include a cut in methane emissions. So In terms of whether or not the conference was successful or unsuccessful, there was a lot of hype going into the conference, a lot of press attention, and arguably it was never going to quite live up to that hype. Ultimately, what all of the pledges and efforts reached at the conference seek to achieve are tangible results in terms of meeting the Paris temperature goals. When the Paris temperature agreement was reached, as I think I mentioned, forecasts were that we would see around 3 to 4 degrees warming. The impact of the pledges and agreements reached at COP26, I think the most optimistic estimates, as you can see on this graph, pre-Paris, you can see between 3 and 4, and at the far right, bodies such as the IEA, having reviewed countries' nationally determined contributions and net zero commitments, estimate that temperature rises may be limited to 1.8 degrees, which is the first time that there's been a forecast that's arguably within the Paris temperature goals, if you consider 1.8 to be well below 2 degrees. Other estimates have been less optimistic, with some bodies saying that even after COP26, we're still on course for warming of around 2.3 to 2.9 degrees by 2100. It's inherently uncertain because, for example, in terms of net zero pledges, as the IEA has recognized, the more optimistic forecasts partly depend on whether countries mean net zero for all greenhouse gas emissions or just for carbon dioxide. The COP26 president recognized at the end of the conference that while we've kept 1.5 alive, its pulse is weak and it will only survive if we keep our promises and translate commitments into rapid action. So a lot of agreements have been reached, a lot of pledges, but ultimately if parties don't take concrete actions on those pledges, they don't really mean very much. Domestic implications, it's probably a fairly similar picture. In terms of domestic litigation, which I think Richard will be talking a bit more about the Paris Agreement in some recent climate change cases, but claimants often have difficulty attempting to rely on commitments in the Paris Agreement or getting into the weeds of its interpretation before the domestic courts. So to the extent that the agreements in Glasgow clarify or seek to build upon the Paris Agreement and its ambitions, but with much less strongly worded commitments, the position is unlikely to be any different in terms of litigation. In terms of the extent to which the pact and other agreements entered into by the UK will take practical effect at the domestic level, it partly depends on whether or not they're enshrined in domestic law or policy. This has been recognised by the Climate Change Committee, which has said effectively that the UK needs to start delivering on the wide range of ambitions and policies that it's already set out in its net zero strategy if it wants to meet some of the pledges and targets that it set out in its agreements made at COP26, do things such as review the tax system and carbon pricing across the economy. And the UK will need to consider whether to strengthen its NDC in advance of COP27. Whether or not that happens remains to be seen, and likely will be seen in more detail in the run-up to COP27. One would hope that, given that this was the UK's presidency of the COP and we remain COP presidents until COP27, that the UK will be trying to take at least some symbolic steps to demonstrate that it's delivered on its pledges made at COP26, but we shall see. Thanks.
Flora, thank you very much for that excellent précis of COP26. I mean, at the heart of the climate change discussions is, as Flora pointed out, the objective to get, at the very least, well below temperature change is 2 degrees, still less 1.5. And one always thinks of flooding and polar caps as melting, but of course climate change and temperature change has a vast array of potential implications. And if one looks at, just been reading Jocelyn Stacey's book, The Constitution of the Environmental Emergency, and one of the examples is quite an interesting example that just shows how the consequences can impact in much bigger ways, is the what's happened with a particular creature called the mountain pine beetle. Now, this mountain pine beetle likes to eat a particular type of pine tree, which is called the lodge tree pine. And during the 1970s, management decisions were made to produce, because it's very good, a lot of this particular type of lodgepole pine. One of the things that would happen, though, is in the winter, at minus 35 degrees Celsius for several days, a lot of the beetle larvae would be killed. And so that kept in balance the beetle that preyed and ate the mountain pine trees. But apparently the weather hasn't been like that since 95, 96. And there's been an outbreak of these mountain pine beetles ever since. So much so that they fell like rain out of the sky. Some of the results is not only killing the particular pine, but also creating forest fires. So it's a nice little example of how a small change in temperature has these consequences that go beyond simply being the obvious one. Now, hoping to set us on fire is Richard and Merrow, who are going to look at the recent litigation on climate change. And Flora's already flagged this up. I mean, we may see, or we may, some of the difficulties of trying to implement in the national courts the effect of international agreements. And we may also see how when we take an international agreement such as the Aarhus Convention, the fact that the European Union has been a signatory, and so much of the Aarhus Convention, or some of it, has come through historically the direct effect of EU law. We may be also seeing a consequence also of Brexit, in that without bodies such as the EU being parties to them, we're looking very much at common law traditional approaches to international law treaties, and we'll see now how that is working, where those international treaties have not been incorporated directly into UK domestic law. This is going to be a two-hand tag team, with Richard starting. Richard will be very well known to you, has represented the government on many environmental cases, and has also been involved in for the challengers, particularly in Northern Ireland, on some complicated environmental changes. Merrow already has a growing list of environmental challenges that she's been involved in, whether with Client Earth or with other challenges against fossil fuel developments and other projects. So Richard's going to kick off first, and then there won't be any more interruption from me. It'll go straight then to Merrow, and then I'll come on and we'll look for a break thereafter. Richard.
Thank you very much, Greg. I'm going to try now to share my screen, which hopefully has worked, so that people can see my presentation slide. So in this first part of the climate change litigation update, I'm going to talk about 4 particular cases, 1 which has reached a conclusion, 3 which are ongoing, or indeed maybe the last one hasn't even actually been commenced yet. So these are all in the climate change field. The first one, which is the one that has been decided, is the Elliot Smith case. This is a judicial review of the approach that was taken by the UK government to the UK emissions trading scheme, which is a replacement for the EU ETS, which the UK was a member of before leaving the EU. So this judgment was handed down in 2021, and there was then an unsuccessful application for permission to appeal to the Court of Appeal. So this is a case which has reached its conclusion. There were two grounds of challenge in this case. The first one was an argument of a failure to have regard to a material consideration. And the material consideration, it was alleged, no regard was had to, was the urgency imperative, it was said that there was within the Paris Agreement. And it was said, therefore, that the decision was unlawful because that was left out of account. The second ground was an argument that the UK ETS didn't fall within the statutory purpose for establishing emissions trading schemes under Section 44 of the Climate Change Act. It was argued that the power had been exercised for an improper purpose. Both of those grounds, as I say, were dismissed, but I'll talk through the arguments under each of those and the reasoning for them being dismissed by Mr. Justice Dove. So the first ground was this failure to have regard to what was said to be relevant considerations, and there were, in a sense, two issues that arose from that. The first was to do with the interpretation of the Paris Agreement, and then the second was the question as to whether or not it had been left out of account. So there was an argument that the provisions in Article 2 and Article 4.1 of the Paris Agreement created an imperative of urgency which had to be specifically taken into account. That gave rise to questions as to how the domestic courts deal with the interpretation of the Paris Agreement as an unincorporated international treaty. And there's plenty of case law on the approach that domestic courts ought to take. And the court agreed that that should apply in this case, which is not that the court will decide for itself what the unincorporated international treaty means in the same way that it might do if it was a piece of domestic legislation, but rather the question is whether the interpretation adopted by the government was one that was tenable. Mr. Justice Dove in that case adopted that approach and decided that the government's interpretation of the Paris Agreement, which was reflected within the documents relating to the UK emissions trading scheme, was tenable, and therefore, in a sense, that was the end of it. But the judge went further than that and decided indeed that the government's interpretation was entirely appropriate. So there was nothing obvious, as it were, that had been left out of account specifically as far as the interpretation of the Paris Agreement was concerned. And beyond that, the judge said, in any event, he concluded on the evidence that the decision makers in the case were fully aware of the Paris Agreement and that it had been taken into account in reaching the decision. So that was the end of ground one. As far as ground two was concerned, there were two issues arising there as well. The core of the argument was that the power had been used for an improper purpose because the cap within the emissions trading scheme was set above the projected level of what are known as business as usual emissions, which are the level of emissions that would be expected before the imposition of the emissions trading scheme. And they argued that that would have the effect that emissions would not in fact be reduced. So there were two questions arising from that. The first was a question of statutory interpretation, looking at Section 44 itself, which talked about the limitation of activities causing emissions. Now, claimants argued that limitation had to mean reducing, and that must be the meaning given to the word within the context of the 2008 Climate Change Act. Mr. Justice Dove disagreed with that and held that limiting could mean putting a limit, a cap on emissions. And it's worth bearing in mind that although there was a particular emissions trading scheme that had been advanced, the Act allows any number of different emissions trading schemes to be created. And of course, it's possible to imagine a situation where a particular emissions trading scheme is created in the context of capping emissions, either because that sector is growing, for example, or because as part of an economy-wide response to climate change, certain sectors are capped and others are reduced. So the judge held that the scheme of the Act, the purpose, allowed for limiting in terms of capping rather than limiting, meaning reduction. But the second issue was what effect the emissions trading scheme was actually going to have in practice. And the judge looked at the evidence base and in particular the modelling work, which had underpinned the government's decision making, decided that there was no challenge to that and the court was going to accept it, and that the conclusion of that showed that there would be greenhouse gas emissions reductions, which meant that in a sense, regardless of the particular statutory interpretation, the result of the UK emissions trading scheme was going to be what the claimant said it should be, i.e. a reduction in greenhouse gas emissions. So for either or both of those reasons, the judge held that the UK ETS as designed fell within the scope of the statutory power and was therefore lawful. So having a permission to appeal to the Court of Appeal application dismissed, that was the end of the case. That brings me to the second case, and this is the most recent Plan B challenge, which is a climate change case based primarily on human rights arguments. Permission was refused for this claim on the papers, and then there was a renewed permission hearing that was dealt with by Mr. Justice Bourne. Permission was refused again with a detailed written judgment being handed down shortly before Christmas. Now, since then, Plan B and the claimants in that case are now seeking permission to appeal to the Court of Appeal, but only on the second part of the case, which was the human rights element. And as you'll see from the third bullet point on the slide there were two elements to this case. The first was allegations of breaches of the domestic provisions in the Climate Change Act, Section 13 and Section 58. And then the second plank of it was based on human rights arguments, breaches, it was said, of Article 2, Article 8, and Article 14. That's the right to life, the right to home and family life, and the protection from discrimination. So those are the legal arguments. In terms of the actual substance of it, it was advanced covering four particular matters: climate change mitigation, adaptation, finance, and then fourthly, loss and damage. So the arguments were that effectively the government's action on all four of those topics was in breach of both domestic and human rights provisions. The way that the claimants had pitched their case was to try to use compliance with the Paris Agreement as the benchmark for compliance with Articles 2 and 8 of the European Convention on Human Rights. So the argument was, in order to be complying with obligations to protect life and family life, you needed to be complying with the Paris Agreement. This, of course, then threw up the same question effectively that had been considered recently by the Supreme Court in the SC case, and Mr. Justice Bourne applied that, holding that the domestic courts can't determine whether the UK has breached an unincorporated international treaty such as the Paris Agreement. That's simply not within the function of domestic courts, and because compliance with the Paris Agreement was being used as the benchmark for the human rights claim, that meant that it was unarguable. Looking at it in slightly more detail now, the first plank of it was breaches of the Climate Change Act, as you'll see from the bullet points there are duties to prepare proposals and policies to meet carbon budgets, and also to put forward proposals and policies programs to deal with climate change adaptation. The judge held that the government had complied with those obligations, that the challenge was essentially a disagreement on the merits of whether proposals and policies were good enough. The claimant was relying on a whole series of critical comments, including some critical comments in reports by the Committee on Climate Change, but the judge said, well, that simply is not enough to give rise to an arguable claim. And indeed, the fact that there is this debate shows that the Climate Change Act mechanism is working as intended. So that ground was refused as unarguable, and indeed Plan B and the other claimants are not pursuing that in their current application for permission to appeal to the Court of Appeal. Then on the human rights elements, on the Article 2 claim primarily, but also Article 8, that came down to whether there was an administrative and legal framework to deal with climate change. And the judge held, unsurprisingly, perhaps in light of what we know, that there was, in fact, a framework put in place that deals with climate change mitigation, adaptation, and indeed finance. And it was simply unarguable that the obligation, if it arose, to put in place an administrative and legal framework to deal with the risk to life had been complied with. As far as the fourth element, which was to do with compensation for loss and damage, the judge held that the absence of any provision to deal with compensation on that basis didn't give rise to any arguable breach of any human rights obligations. And indeed, you'll have heard from Flora earlier how that sits with the future of the Paris Agreement in any event. And then also the judge was recognizing that there was a wide margin of appreciation as to how how governments are to go about setting out a framework to deal with threats to the right to life in any event, such that it's not something the court was going to engage with, because it covers high-level economic and social measures, which are essentially areas where the government is given a very wide margin of appreciation. Then on the family life claim, that was essentially dismissed on the evidence, because as far as the claimants' family life within the UK, there was no evidence of that being threatened. And although there were references to family members outside the UK, the evidence did not show that the high threshold for Article 8 to be engaged in those circumstances was actually met. But in any event, the same kind of challenges would have been faced in relation to the existence of a framework to address climate change, as I've just explained. There were various other arguments in the case, including in particular that none of the claimants could establish their status as a victim to be able to bring the human rights claim in any event. So that's where that case stands. Then the third case I'm going to mention is one which was heard in December. This is the Friends of the Earth case, and where judgment is awaited. This was a challenge to a decision that UK Export Finance would provide export support in relation to a liquefied natural gas plant in Mozambique. And there were effectively two grounds of challenge that got permission, both different aspects of climate change. There were other angles, other grounds in the case originally that didn't get permission to proceed. But the first of those two was taking issue with conclusions that the project and providing export support in relation to it were compatible with the UK's obligations under the Paris Agreement and Mozambique's obligations under the Paris Agreement. And then the second element of that was an argument that the conclusions that were reached as far as climate change and the Paris Agreement were concerned left out of account relevant considerations. So we've not got a decision on this yet, but I've just highlighted in this slide some of the issues which arise in the case. There was an issue about the standard of review, the approach that the court should take to this argument about what the Paris Agreement requires, and that refers back to the tenability arguments that I've mentioned in relation to, in particular, the Elliot Smith case. Also, because this was engaging debate about whether Mozambique was complying with its Paris Agreement obligations, there was an issue about the foreign act of state doctrine and whether a UK domestic court could consider whether Mozambique was in breach of its Paris Agreement obligations, and indeed how much of the case was covered by that general approach. There was then argument about the precise meaning and effect of the provision in Article 2.1c of the Paris Agreement that talks about aligning finance flows with the low emissions pathway. And then some of the issues that arose under ground 1b in particular covered scope 3 emissions, which are greenhouse gas emissions from the use of the LNG that was going to be produced by the project. How did they have to be assessed? Did they have to be assessed on a quantified basis? And then was the overall assessment of the climate change impacts irrational? Were considerations left out of account? So those are the issues that will perhaps be considered by the court in that case. So look out for the judgment there. And then the final case that I'm going to mention just very briefly is one where it's been in the news, I think, this morning, reported that there's challenges to the government's net zero strategy going to be brought by Client Earth and Friends of the Earth, arguing that there's been a failure to comply with sections 13 and 14 of the Act. Section 13, of course, requires the Secretary of State to prepare proposals and policies as they consider will enable carbon budgets to be met. And then section 14 is the duty to report on that to Parliament. So the case really raises questions about the interpretation of those provisions. We've seen some of the arguments have been mentioned in the press today, and I've set those out certainly from the Client Earth challenge in the first bullet point there, and then attempted to flag what might be considered by the courts in this case. Now, we all know, as far as judicial review is concerned, the court is not going to consider the merits or the substance of the net zero strategy. It's going to be, it seems to me, largely about the statutory interpretation. What do sections 13 and 14 require? Questions like, do policies and proposals have to be concrete and detailed? Is there an obligation to quantify the emissions reductions of policies and proposals, individual policies and proposals, or for sectors as a whole? And how detailed does a section 14 report have to be? So we'll see how that case actually unfolds in detail. And of course, whether there's any arguments there that the court grants permission to go forward. I mean, it does seem to me on the face of it that really there are challenges to the merits of the net zero strategy, but that is another one to watch. So with that canter through those four cases, I will now hand over to Merrow, who's going to discuss a number of other cases. You're on mute, I'm afraid, Merrow.
There we go. Hello. Hopefully that's worked. I'm just going to now do the sharing of my screen. Bear with me. Great. Hopefully you can all see that okay. And thank you, Richard. As Richard said, essentially I'm going to take over and I'm going to cover a few more climate change cases from sort of the last year. And in the limited time, I can't cover them all, but I've tried to pick a few that hopefully will be of some interest. So to kick off, I'll start with a case that I was actually involved in as a junior for the claimant. And this was one of the sort of older cases of last year, but I think in particular, it's led to a process that is now ongoing. So I think hopefully it will be of interest. It relates to a challenge to a development consent order for a major junction improvement scheme to the A38, consisting of the construction operation of 3 replacement roundabouts. The challenge was brought by a local resident, but one who had been actively involved as an interested party in the examination process. I think it's fair to say that climate change impacts were a key controversial issue during the examination process, and the examining authority dealt with climate change impacts at some length in their report. And worth noting that the applicant's, Highway England in this case, the applicant's environmental statement did consider greenhouse gas emissions of the project, but the statement did so by reference to the old 80% reduction target and the Climate Change Act, and not the new net zero target. And essentially, the Secretary of State conceded that there had been a failure to provide a reasoned conclusion as required under the relevant EIA, Environmental Impact Assessment Regulations, or in any event, a failure to include a reasoned conclusion in the decision notice. Just a bit more on this is, you can see here that the examining authority essentially said on a number of issues that they didn't feel that they had sufficient evidence and information from the applicant on various points relating to climate change impacts. So on this slide, you can see in relation to the Paris Agreement, the examining authority said, we consider that not enough robust evidence was presented to us to reach a view about whether the proposed development, or indeed the road investment strategy programs of which this project formed a part, there are a number of projects in that program, whether they would be consistent with the Paris Agreement. And on cumulative impacts as well, similarly, the examining authority essentially said they didn't have the assessment materials on cumulative carbon impacts. And that essentially led them to say to the Secretary of State in their report, there are a number of points here where we can't reach a conclusion. By all means, if you can, it's open to you to do so, but we can't on the information that we've been provided with. So I've noted already that the first point is whether or not there would be compliance with the Paris Agreement or a breach of the Paris Agreement. The second point is that cumulative assessment point, and you see there the examining authority giving an example of how they say, in their view, a cumulative assessment could have perhaps been done by reference to the RIS programs and comparison comparing them with the UK carbon budget. And then thirdly, they also note that they were not able to conclude on whether the proposed development would affect the ability of the government to meet the net zero target, essentially. And this next slide, I would say, is one of the key paragraphs of the Secretary of State's decision letter addressing carbon impacts and cumulative impacts. And you can see here that the Secretary of State essentially says, I'm satisfied that there's been appropriate consideration of carbon impacts in terms of the RIS programs during their development, and that any impacts not incompatible with the relevant targets. I'm satisfied there was appropriate consideration of cumulative effects, and concluding ultimately that I'm satisfied that any increases in carbon emissions from this development are not going to be so significant that they would have a material impact on the ability of the government to meet the targets at issue. And so the issue in this case was quite simply that, or the point that was conceded on by the Secretary of State related to the fact that simply stating these conclusions was not providing the reasoning underlying them, or certainly not providing reasoning that could be scrutinised by other interested parties. That was the case for the claimant. And in particular, it was emphasised for the claimant that the EIA regulations require an up-to-date reasoned conclusion. And the emphasis was put on the fact that, as I mentioned, the environmental statement before the examining authority was based on the, by then outdated, well, by the time of the examining authority considering it, the outdated 80% reduction target. And so there was emphasis in this case about the need for an up-to-date reasoned conclusion. And as I said, the Secretary of State conceded on this point, so the matter has gone back to the Secretary of State for reconsideration, and that's a process that is at this time ongoing. The next case that I wanted to cover is the case, the Greenpeace case, which is a decision from October last year from the Scottish, the Inner House of the Court of Session in the Scottish courts. And in terms of the facts, it relates to the fact that BP had applied for a consent from the Oil and Gas Authority for 2 new production wells in the Vorlich oil field in the North Sea. And essentially, under the offshore petroleum production and pipelines regulations, I'm simplifying somewhat, but essentially there is a 2-step process for getting that consent. Firstly, the Secretary of State needs to agree to the consent, and then it then goes to the OGA to grant the consent. And in that sort of 2-step process, it's the Secretary of State that needs to consider or is responsible for assessing the environmental impacts. And in short, it's the usual EIA regime that applies here. Now, the case has a relatively complicated backstory and sort of procedural history, and there are other grounds in this case relating to alleged procedural failings, mainly turning in relation to how the application and the decision have been published for the public. And I'm not going to deal with those points because what I want to focus on here is the ground that related to consideration of climate change impacts and emissions impacts. And so you can see in the slide, the main issue is whether the environmental impact, not of the exploitation process itself, but also of the consumption of the extracted. I've gone back a slide. Sorry, I've missed a slide. Here we go. Of the extracted and refined oil, whether that environmental impact of sort of the end use of the extracted oil and gas is a relevant consideration. And I just note that's the way it was stated in the judgment. It's quite broadly stated in terms of the point at issue. This is my best attempt at a sort of clip art flow diagram here to show where we're at in the sort of stage process in this case. So dealing with the production wells, obviously after that, the oil would be refined before it would then be used and consumed. And this is a short extract in terms of what the EIA regulations are requiring here. You need to be assessing not only the direct, but the indirect significant effects of the project on climate. And the question, the key issue was whether the emissions associated with that end use is an indirect effect of the project. And the answer, as you can see in the slide, is simply no. The court held essentially that it wasn't an indirect effect of the project, and that the applicant and the Secretary of State only needs to really concern themselves with a determination of the significant effects of the actual drilling the 2 wells and removing the oil and gas, as well as the sort of depositing and operating of the oil rigs. But it does, they don't need to go any further and assess impacts beyond that. And perhaps this decision might not be a huge surprise to anyone who's familiar with the Finch case, which was a decision in December in 2020, which is subject to appeal. I believe the appeal was heard in autumn last year, but we're still awaiting judgment from the Court of Appeal on it, and essentially came to very much the same decision in the Finch case. That concerned, for a very quick refresher, that concerned a permission that had been granted for the retention and expansion of a site producing hydrocarbons on land. Interestingly, the scoping opinion for the environmental statement in Finch had suggested that there should be an assessment of emissions relating to end use, but the environmental statement didn't cover that. It restricted an assessment to the emissions associated with the operations. You can see that it was accepted in the quote in the bottom of the slide. It's accepted that the extraction of this crude oil would result, essentially inevitably, in greenhouse gas emissions associated with onward use, end use. And so the same question arose as in Greenpeace. Does the EIA regime require a developer to assess the greenhouse gas emissions of that onward use? And again, Mr. Justice Holgate concluded that it did not. I note that Mr. Justice Holgate did state clearly at the beginning of the judgment on this matter that this is a case that's likely to have wide-ranging consequences, not just in terms of climate change, but actually generally in terms of assessing environmental effects, where you have a sort of staged or phased production process. So it might not just be related to climate change impacts. This is a key paragraph from Mr. Justice Holgate's decision in Finch. And what he says is the test here is not a test of inevitability, of what it will inevitably flow from the development. The test is whether the environmental effect is an effect of the development for which planning permission is sought. And the claimant in Finch had actually accepted that the development was that which was authorised to take place on the site. This wasn't a salami slicing case. This wasn't put in that way. They weren't saying that the development is in truth everything in terms of the extraction and the refinery. They accepted the development was really the extraction site. But what the claimant was saying was, when you think about indirect effects of that development, you need to think about anything that is attributable to the development. And that was rejected essentially by the court. But I think an underlying concern of this case and of Greenpeace is sort of, where does responsibility lie for assessing emissions impacts? So if we turn back to Greenpeace, I can see Greg has come on the screen. I hope that doesn't mean I'm running out of time, but I will continue on. If you go back to Greenpeace, there are just a few further points I think it would be worth noting. The first is the court in Greenpeace reiterated something that was said in Finch, which is essentially the regulation of climate change impacts, according to the courts, is a really a political matter. It's tackled, the court says, nationally through the government's efforts and plans to transition to a low carbon economy and society. And at global level, it's tackled through the Paris Agreement. That's what you see the reasoning of the court in both Greenpeace and Finch pointing towards, moving the debate about climate change impacts away from a project-specific level debate and towards an overarching policy framework debate. The second point is both cases highlight some of the practical issues in assessing greenhouse gas emission impacts. So how do you work out, especially of end use, so how do you work out if your project is actually going to result in an overall increase in emissions? Would those emissions and end use, in terms of end use, be happening anyway? Would they actually be worse without your development, because you would need to import fuel from further afield, for example? And you can see the court grappling with those kinds of issues in the slide. But it's also something that came up in Finch as well, where there was a question mark about how will this development actually result in the level of onward emissions. And thirdly and finally, the point I would draw is it's worth thinking about, I think, the ambit, I mean, with a footnote that Finch is subject to appeal, so it'll be interesting to see what the Court of Appeal says on all of this, but it's worth thinking about the ambit of both Greenpeace and Finch cases. Both were focused on the environmental impact assessment regime, and both were dealing with challenges brought where a decision maker has decided not to consider the climate change impacts of onward use. And I think an interesting question left open is really potentially, to what extent can a decision maker consider onward use emission impacts as part of the planning process? Is it open for them to do so? And these quotes, I think, are interesting in that context. You can see in the Greenpeace quote, I read the decision as being based on the terms of the EIA regulations. And in fact, this quote, which I haven't got the whole of it in there, but at paragraph 66, it goes on to talk about contrasting the Greenpeace case with a case such as the H.J. Banks case, where it had been accepted between the parties, at least for purposes of that litigation, that end use could be a relevant material consideration, for example, in the planning process. But then you see in Finch, I think it's interesting, these quotes from Finch, which appear that seem to be talking about planning control in a broader sense, and query the extent to which they are intended to be covering situations outside of the EIA regimes. And picking up just one point here, the court does seem to be saying in that last quote, well, development control is really concerned with the use of land and the effects of that use, and it's not concerned with the effects that result from the consumption of the end product. But it's an interesting point I think others have raised, is where the line is drawn in planning. I think anyone who's been involved in planning inquiries and the debates that can be had in planning inquiries, it's quite common for parties to raise for example, economic benefits associated with onward expenditure that you would expect from residents moving into a new development, for example. And so where's the line in terms of the indirect sort of impacts and how that factors into the planning system, I think is a very interesting question in light of these cases. And then finally, very conscious of time, this is another case I wanted to note, another case that I have been involved in as a junior for the claimants, but it is ongoing and we are awaiting judgment, so there's a very limited amount that I can say. But it's essentially a challenge to the Oil and Gas Authority's strategy, a new strategy brought by 3 climate activists. Essentially, the Oil and Gas Authority is required under statute to set a strategy, and that strategy must enable a statutory objective to be met, and that objective is the objective of maximising the economic recovery of UK petroleum. And there are 2 grounds of challenge in this case. The first was put on the basis of an error of law or frustration of the statutory purpose, which is in relation to the point made by the claimants that the strategy incorrectly essentially defined the principal objective in the way they defined it, and thereby frustrated the statutory purpose of the Petroleum Act, Section 9A. And the second ground of challenge was in relation to whether the strategy, in terms of how it's defined, the term economically recoverable, whether it was irrational in light of the strategies, same strategies stated aim of assisting the Secretary of State to reduce as far as reasonable in the circumstances the greenhouse gas emissions associated with the recovery. I can see that now David has joined the screen, which must mean that I'm over time, so I will stop there, I think, but hopefully there's a few more, those are a few more interesting cases in the climate change field.
Thank you, Merrow. David has now joined us. We're going to, in a moment, break, but Merrow ends, or almost ended on the first finally, when she touched on material considerations. She's absolutely right, raises a huge issue, which could go, as Merrow says, beyond just the greenhouse gas issue, because as she says, if you're going to take in the secondary, where do we draw the line? Are we going to draw in collateral benefits? Should we of consumption? Should we take into account collateral impacts on the environment of consuming products? One can, if that were the case, one can readily see the difficulty in how one would make a potentially a meaningful assessment, but one can also see the breadth, as Merrow indicated, of what that could mean. We're awaiting the Finch decision. In the West Cumbria mining case, Friends of the Earth and others maintained the same position that was unsuccessful in Finch, but at first instance, namely that one should assess and take into account the onward downstream effects. In that case, the issue, they limited it to greenhouse gas, but if they're right, presumably it would extend to all types of environmental consequences. Now we're just going to have a very short break and aim to start back at 4:15 with Ned Westaway, who's going to highlight some acute issues arising in terms of air quality. So we will be back on your screens, if you turn them back on, at 4:15. I'll thank all the speakers at the end, but I just want to thank Merrow, Richard, and Flora for an excellent first half set of presentations. I will be back on in now 4 minutes. Thanks. Hello. Sorry, what did you, for the sanctuary eating?
Greg, you're unmuted.
Sorry. Thanks, Flora. Well, welcome back, everybody. It's actually 16 minutes past, but we hadn't. But that is a 5-minute break. We're now going to move on to, I hope, Ned Westaway, and on to air quality. And I'm relieved to see the PowerPoints come up before I can see Ned. But it's good to know that you're here, Ned, in whatever mysterious capacity.
I'm here. I'm
good,
here.
Good. That's excellent. Ned is the leading light of the environmental bar, chair, I think, still of UKLA, and an expert in this and other environmental aspects. And I'm now going to ask Ned to put into perspective the Environment Act in terms of air quality. Thanks, Ned.
Thanks, Greg. Thanks, everyone, for logging in. So I've given myself the topic air quality, and in part, that's the Environment Act. In part, it's beyond the Environment Act. In part, and this flows from where we got to, air quality links to climate change, of course, because climate change is an air quality issue in many respects. And in EIA, traditionally, climate change impacts were addressed under the air quality chapter. I think that increasingly changes now and is addressed separately. What I spoke about last time when we covered one of these environment seminars was about the Environment Bill, and David Graham's going to come on and talk about the Environment Bill. And it's now an act, of course, but it was a bill back then. It was the 14th of October. It was the very end of the parliamentary process, and there'd just been the third reading in the House of Lords. I made various predictions about what would happen to the raft of amendments that were put forward by the Lords at the very last minute in that process. And I just wanted to digress very briefly at the beginning of this. How did my predictions fare? I think Greg thought that none of them would come true. Most of them certainly didn't, but there were two amendments which I thought were more likely to find expression of some form or another in the bill. And this is at the ping pong stage, what's formerly called double insistence. And I think I can argue that I got those about right. The first was Amendment 24. Now, that was about omitting provision for the Secretary of State to give guidance to the Office for Environmental Protection. Well, there was no amendment to the Act, but the Minister, Rebecca Powell, did make a statement in Parliament to say that the government would not exercise its power to produce this controversial guidance in the first instance, and would give the Office for Environmental Protection a free hand in the initial expression of its enforcement policy. And as I understand, the Office for Environmental Protection is busy preparing its enforcement policy unfettered by separate statutory guidance. The second was Amendment 27, and this was promoted by the eminent lawyer, Lord Anderson, and it was a relatively modest amendment trying to give the court a bit more flexibility on environmental reviews. And this did lead to some degree of compromise. It's a little convoluted, but effectively there's a bit more flexibility for a court on an environment review to grant a remedy, even where maybe many years after the event, there is substantial prejudice to third parties or to public administration. Anyway, digression over. Royal assent has now happened. That happened in November last year. And I'll come on to that. I want to get on talking about air quality. How I'll outline this is I'll set out the existing framework, then I'll come on to talk about the new provisions in the Environment Act. If there's any time left, I'll make a couple of points by way of reflection. Do plug your questions into the Q&A box insofar as you have them. I think we have a short amount of time, just before 5, to deal with any questions arising from any of our talks. So I think that clean air is one of these areas that is covered by an enormous amount of law. There's not a single legal framework, there's many. I've sought to divide them into three for the purposes of this talk. And the first main type of statutory control on clean air is specific or point source controls. Perhaps the major one of these is currently the Clean Air Act 1993. The Clean Air Act 1993 regulates dark smoke from chimneys, among other things, establishes smoke control areas. There's plenty of others, effectively point source controls on furnaces and other forms of installation that pollute air. The second one, and quite an important one, is Part 4 of the Environment Act 1995, and this is what's called local air quality management. This, as many of you will have seen, has a number of different main planks to it. There must be a national air quality strategy that sets standards and objectives for clean air in a number of different areas, ammonia and other things. Local authorities then take the lead, and they must review clean air or air quality in their areas. And if standards are not being achieved, designate air quality management areas, AQMAs, and prepare action plans to improve air quality. There's various reserve powers as well. There was a recent case on Part 4 of the Environment Act 1995, and it's of note because it's rarely litigated. These what's seen as broad duties under the 1995 Act have perhaps led to surprisingly little litigation in the courts. And this was a recent case relating to experimental traffic orders. I think it's fair to say that the litigants' main concern wasn't air quality, it was that they wanted the roads to remain open for their cars to go up and down them. But one of their arguments was that by closing roads to cars, they were being forced into other areas with air quality management controls on them, and it was worsening clean air, and that had not been considered. Hackney Council argued that the claimant could not rely upon breaches of duty under the 1995 Act because it was simply too broad in nature. And what's interesting is the High Court, Mr. Justice Dove, didn't entirely accept that submission. He said that effectively the framework in the 1995 Act is and was clearly a material consideration, and went on to say, para 62, that it might be a critical consideration. Simply in that case, given it was an experimental order, it hadn't reached that level of criticality. HHRC, interestingly, stands for Horrendous Hackney Road Closures. So that's the second main plank. The third main plank in this slightly artificial division I've made is retained EU law controls. And again, there's a raft of these. By far the most important, preeminent one is the Ambient Air Quality Directive. That's the 2008 directive that I list there. And what that does is to set limit values in law, so not in guidance, in law, and assessment thresholds. It also includes some quite detailed mandatory monitoring provisions and requires in a number of areas, but particularly nitrogen oxides, particulate matter or PMs, and sulfur dioxide, those thresholds to be met by a certain date. It's quite ambitious, and the thresholds have not been met by that date. So it's been more honoured in the breach. In fact, there was perhaps one of the last enforcement cases brought by the Commission against the UK was handed down in March last year on air quality. So this is an area that's been much busier in the courts, and the Client Earth litigation, which ran really for 8 years, and government lost eventually, and then lost another couple of claims in that case, established that government needs to do more to substantively comply with those standards. I think it's fair to say that the Client Earth litigation is the cause celebrus for the environment law marathon of our times. But it's sort of petered out now, and it petered out a few years ago with government giving directions under the Environment Act 1995. So linking back to local air quality management, on authorities to produce their own plans to meet the EU regulations. So you can see how these two planks have sort of been brought together by government's response to litigation based on the EU regulations. Briefly, very briefly, human rights question mark. There was a very interesting decision in September, Richards, relating to Wally's quarry in Newcastle under Lyme. And in that case, Mr. Justice Fordham found, in a claim based on human rights, that the Environment Agency had breached obligations under human rights because they were not doing enough to minimize exposure to hydrogen sulfide for young Matthew Richards, who was a particularly sensitive individual. And a surprising judgment in a way, but a very full and thorough one, because there was no national standard for hydrogen sulfide. And in fact, there was a bit of an information gap about hydrogen sulfide. So that decision was unsurprisingly appealed by the Environment Agency. All we know is that the appeal was successful. We don't know yet why, but just before Christmas, the Court of Appeal indicated that it would allow the appeal and reasons will follow. So look out for those. So that brings me on to the Environment Act. And the Environment Act does not seek to consolidate or bring air quality law all together in one place. It doesn't tie everything up. In fact, what it does is present a bit of a miscellany. It relies on some old things, it adds some new things, and arguably it complicates the picture even more. The two parts that are particularly interesting for us are part one. Part one is the general governance part of the bill, and part four that specifically relates to air quality. So I'm just going to outline pretty briefly what's in those parts. Part one is relevant because air quality is identified as one of the priority areas for the purposes of the Environment Act. And indeed, very fine particulate matter, what's called PM 2.5, is identified as a special area in which targets must be put forward. And the Environment Act for those priority areas and on PM 2.5 sets out or requires government to bring forward binding long-term targets. These are to be set out in regulations that we'll see later this year. I understand there's various working groups in each area looking already at those regulations. And they must set out a standard and a date by which that standard is to be achieved. Long-term means no less than 15 years, so it kicks it off a little bit. But particulate matter does not need to be a long-term target. Particulate matter could be less, and I suspect it will be more like a 5 or 10-year target. These are binding because the Secretary of State must ensure that the target is met. And it's enforced, among other things, by reporting duties to Parliament. If by the reporting date the target has not been met, the Minister must provide a report. Query what the targets will be, query exactly how this will work. At a recent event that I attended, the Minister, George Eustace, talking about targets, he referred to a population exposure target. So a slightly different kind of target to what we've seen before. Perhaps where one's looking not at the absolute level, but the number of people who are affected by air quality. So these targets could replace, or they could run parallel to, or they could be entirely additional and separate from the existing targets in the National Air Quality Strategy and in retained EU law. Interim targets, I'll briefly mention, these are not binding in the same way, but they're more of the perhaps delivery process under the Environment Act. Perhaps they have more immediate practical relevance. And interim targets must be set out in the Environmental Improvement Plan, which must be brought forward again under the Act. These again must be measurable, they must set a standard, and they must have a date by which they are to be achieved. And they're subject to regular reporting and scrutiny from the Office for Environmental Protection. That's the OEP. So that's broadly how air quality fits into the big structure, if one likes, of the Environment Act. Now that we've had that one, this is the next bit. Part 4. So in part 4 is on air quality, and it does a number of things. Again, I'll rattle through this, but perhaps the most significant for practitioners are the changes, and these only apply to England, as does the whole of the Act. It really applies to England primarily. Are the changes to local air quality management under the Environment Act 1995. And interestingly, while setting out a separate framework in part 1, the Environment Act also strengthens the local authority governance framework for England under the Environment Act 1995. So a number of the things it does are to require a regular review of the National Air Quality Strategy, to require annual reporting upon it, to make it, insofar as it wasn't expressly set out before, to make it a duty for local authorities and other bodies to have regard to the National Air Quality Strategy, and to add some more specific outcomes for local authority reviews. So a review now has to identify the source of air quality pollution and the responsible bodies. It also adds provisions about coordinating between different local authorities and other bodies, so the Environment Agency being the main one. So it significantly strengthens the 1995 Act. And the last two things I'll mention very briefly. Under Part 4, there's a tightening up of the controls under the Clean Air Act 1993. So this is about use of solid fuels and burning. There's addition of financial penalties and things like that. And there's new provisions on environmental recall. These are relevant to air quality because the primary focus is on vehicles and engines. And I've got no special knowledge of this, but I can imagine that diesel generators and diesel vehicles are the kind of things that government might be thinking about under environmental recall. Regulations need to be brought forward. I don't think there's any draft regulations yet, but there's essentially a power to bring forward regulations to get rid of dirty tech. Reflections. Things are a little up in the air. It's hard to tell where exactly things are going to land. And we still have now a multiplicity of different regimes with some obvious overlaps. The reporting under both the Environment Act 1995 as amended by the Environment Act 2021, but also the different sets of standards. So there's a number of different regimes applying, and it means for a practitioner you need to be aware of all of them and take a pretty broad focus, I think, when looking at air quality. I suspect that when government brings forward the regulations under Part 1 of the Environment Act, there will be an attempt to have some coherence, some recognition of the different bits of law in this area. I also suspect that it will be covered in the Environmental Improvement Plan. I suspect there will be some attempt to pull together the different standards and different focuses in the Environmental Improvement Plan, so that in practice, the most important piece of legislation, or the primary piece of legislation on air quality, does become the Environment Act 2021. But there's no doubt that there's other sources of law that will remain, certainly in the meantime, really quite important. How's that, Greg?
That's excellent. Thank you very much, Ned. And I remember some years ago when Michael Fordham was still at the bar, being involved with him on various challenges to the burning of so-called secondary liquid fuel, which some people tuning in will remember, in cement kilns. So in those, God, it's making me feel old now. Those days, people weren't talking about cement and greenhouse gas, but talking about the air quality, worried about the air quality impacts of so-called secondary liquid fuel comprising waste from the paint industry. And one of the cases I know Michael was involved in involved very much the impact on a young boy's health in terms of air quality and human rights. So maybe we see a little of that coming through in the judgment. I mean, it may be interesting at the end we can reflect on whether we think the judiciary and the laws are matching the sense of the wider public perception of the environment when it comes to the actual application of the law. But Ned, thank you very much. And I'm not sure I said that none of your suggestions would get through, but we'll have to go back and look at the video, see who wins the bet. But thank you, thanks very much, Ned. And we're going to turn finally to David Graham. And excellent, good to see you, Dave. David is going to be speaking, drawing out some non-air quality aspects of the Environment Act, and it's particularly good that he is, because this is going to be something that may begin as a bit of a cut and paste and some twiddling around from Brexit, but is, I think, going to develop it's obviously its own body of case law. So David, if you can take us to where we think we are at the moment.
Good afternoon, everyone. So I'm going to hopefully share my presentations. What I'd like to start off with is just to remind everyone essentially how far we've come and how long we've taken to get to the point where we now have an Environment Act. We've been doing these seminars quarterly, and we've covered each stage in the process. But it was striking, going back preparing for this talk, that actually the first consultation on what was then a proposal for a bill was in May 2018, and it's featured now in 3 Queen's speeches, and we finally got where we are. But I think most people, while making due allowance for the COVID pandemic, would say, particularly having just listened to Ned's presentation on air quality, that this is somewhat of a missed opportunity, because we really have got a very disparate and fragmented system, if we can call it a system, of environmental regulation. And what this bill does is it really just carries on with that. And a lay person looking at large parts of this act will just see amendments to provisions in disparate other statutes elsewhere. And it's very hard to see how this is actually a coherent system for environmental law. So what I propose to do is just briefly outline, first of all, what the structure of the Act is, and then look in detail at just one aspect, because in the time allotted to me, there's no way that we can cover each of the thematic areas that are addressed by the bill. And it may be, I'm sure it will be the case that in future quarterly seminars we'll look in detail at some of these subject areas. But I'm going to look back at the first part of the bill, which is where it all started, which is the governance provisions, and what was then originally released as a draft environmental principles and governance bill back several years ago. But we can see that the Act is structured in such a way that the first part deals with governance. There's a second part on Northern Irish governance. Then we have a part on waste and resource efficiency, which in essence is a framework piece of legislation which confers powers on the minister to make regulations on regulating both of those topic areas. We've then got part 4 of the Act, which addresses air quality and recall, which Ned has covered some extent in the previous talk. Part 5 addresses water resources. Part 6 and 7 relate to biodiversity, new provisions in relation to planning, and then conservation covenants and how those are going to work. And Part 8 is a miscellany, which has of chief note, it has provision in relation to the REACH regulations on chemicals. And each of these areas really could deserve a full slot at the seminar, but I'm going to focus on governance. And the governance aspects really are all about setting up the objectives for environmental policy in the medium and long term. And I've structured it in this way. There's a setting of targets. There is a requirement to make a long-term policy statement. There are provisions for environmental improvement plans. There's provision on monitoring of progress on the environment. There's provision for various statements to Parliament by the Secretary of State. And then there's provision for the Office for Environmental Protection. I'm going in the remaining 15 minutes or so to look at those provisions in a little more detail. But I think what one will be struck by, and that's why I've put the cheeky cartoon on the slide, is this is really a case where so much latitude is given to the Secretary of State that to set their targets and also to set how those targets are to be monitored and measured, that if they don't hit their targets at the end of the process, then something will have gone seriously awry. So starting off at the beginning of the Act, in Section 1, it addresses the setting of targets. And there is a power and a duty. There's a power to set long-term targets that relate to the natural environment or to people's enjoyment of the natural environment. And then there is also a requirement to exercise that power to set a target in respect of at least one matter within each of the enumerated priority areas. And those are air quality, water, biodiversity, and resource efficiency and waste. So what we've got there is effectively a requirement to set at least 5 different targets. And we're told that these targets have to be long-term, which means no less than 15 years after the date on which they are set. And there is some considerable amount of provision for the process whereby these targets are to be set. And then at sections 2 and 3, there are 2 specific additional requirements to set a target in relation to particulate matter, PM 2.5, and a target in relation to the abundance of species. And these targets may be short-term, they don't have to be the 15-year targets that we find in relation to section 1. Now, how is that to be done? Well, we're told that the Secretary of State has to take and receive advice from persons that they consider to be independent and to have relevant expertise. The targets, we're told, must be measurable. And the regulations that will set the targets will then set the reporting date and may set out how to measure the target. The Secretary of State has to be satisfied that the targets can be met at the point when they are set. And there is then a duty under section 5 to ensure that the targets are met. Interestingly, there is also then a power to amend or revoke the targets where the Secretary of State is either satisfied that there is no significant benefit in a stricter target, or they consider that because of a change in circumstances, the costs, which include environmental, economic, or social costs, would be disproportionate to the benefit of meeting it. So quite how that sits together with the duty to ensure the target is met isn't entirely clear, but we can see there that given that the targets can be adjusted at any point, the Secretary of State jolly well ought to be meeting the targets that they set. And of course, I just note that where it says no significant benefit, it is a question on which effectively there is a sort of Wednesbury standard for deciding what is a significant benefit as against the cost of meeting the target. What we are told, though, is that there's supposed to be a review under Section 7 every 5 years as to whether the targets would significantly improve the natural environment in England. So they're supposed to be set effectively in the expectation that the target will significantly improve the environment. And that implies, therefore, that every 5 years, there has to be a further significant improvement, and that effectively Section 7 is a kind of ratchet. Then we have the question of policy. Section 17 requires there to be a policy statement on environmental principles, which are the principles transferred in from European law, and Article 192, I think it is, of the treaty, and they're set out at subsection 5, which is on the slide. But interestingly, the policy statement is to be a statement explaining how the principles should be interpreted and proportionately applied by ministers when making policy, which is interesting in a number of ways. From a constitutional point of view, this is a rare instance of ministers deciding for themselves how to interpret a principle. Secondly, it's interesting because we are in the realms of a policy statement that only applies when making policy. Presumably that's to be distinguished from implementing policy. So quite how that works is still to be worked out. The Secretary of State has to be satisfied that this statement will contribute to improvement of environmental protection and to sustainable development. How much contribution in terms of how ambitious the policies are supposed to be in regard to these principles is left for the Secretary of State. There's a process that's set out by Section 18 in consulting such persons, I think implicitly, if any, as the Secretary of State considers to be appropriate, and then the Secretary of State has to lay a draft of the statement before Parliament for 21 days, but the procedure doesn't require any procedure whereby Parliament has to either vote to adopt the statement or it doesn't give Parliament a veto either. There's no negative resolution procedure, but the Secretary of State must at least respond to any resolution that is passed by either House of Parliament. The effect then at Section 19 is that the minister must, when making policy, and only when making policy, have due regard to the statement on the environmental principles. And again, the questions of significant effect, benefit, and the proportionality have to be considered. And then if we look at what is exempted, anything to do with taxation, spending, or the allocation of resources within government is exempted, which somewhat undercuts the principle that environmental considerations are to be integrated across all areas of policy. Third strand is the requirement to prepare an environmental improvement plan for a period of no less than 15 years. The statute has adopted the DEFRA 25-year plan to be the first improvement plan under the statute. And again, the question is whether the minister is satisfied that meeting a target or revised target will make an appropriate contribution towards meeting the statutory targets when you set targets in the plan. And again, there's a lot left to really to individual secretaries of state in terms of how ambitious they wish to be. There's a whole suite of statements and reports that are required of ministers. We can see a parallel, for instance, with the Human Rights Act, that there is an obligation in relation to any bill which contains an environmental law provision, which is defined to mean a provision that mainly affects the environment and it isn't a taxation or resource provision, they have to make a statement as to whether it would be environmental law and whether it would reduce the level of environmental protection, although this doesn't require the minister to refrain from regression on environmental standards. There's provision for monitoring, which are to be such arrangements as the Secretary of State considers appropriate. So having rushed through those provisions, we can see that effectively it is a matter for the ministerial discretion how ambitious they wish to be on environmental protection. The second strand of environmental governance is the foundation of the Office for Environmental Protection, which has now been launched with a new logo and website. It's a shield. I think it's supposed to also be a leaf, its logo. Now, Schedule 1 to the Act sets out the powers and funding arrangements of the office. Interestingly, it says that the staff are not to be civil servants or agents of the Crown. They cannot be serve as members of the legislature. The funding is to be provided by the Secretary of State and not directly from Parliament. The Secretary of State has to provide such sums as they consider to be sufficient for the performance of its functions. And under paragraph 7 of the schedule, the minister must, in setting the budget and in all of the other functions in relation to the OEP, must have regard to the need to protect its independence. And then there is provision at paragraph 14 for the OEP to issue a statement of accounts, which has to include an assessment as to whether or not it has been provided with sufficient funds. So there are some checks and balances built in to at least prompt ministers to secure sufficient funding for the OEP. And interestingly, by paragraph 8, subject to some restrictions around receiving gifts and setting up companies, the office may do anything it considers appropriate for the purposes of or in connection with its function. So it has got a broad discretionary power. What are the functions? Well, section 23 tells us its principal objective is to contribute to environmental protection and the improvement of the natural environment. We're told that it must act impartially and objectively and have regard to the need to act proportionately and transparently. And then it is required to set out a strategy as to how it intends to exercise its functions, including an enforcement policy. The OEP is required not to overlap with the Climate Change Committee, and it's supposed to respect the integrity of other statutory regimes. And the strategy has to secure that it prioritises cases that have national implications, relate to ongoing or recurrent conduct, raise a point of law of general public importance, or relate to environmental damage which is considered to be serious. The Secretary of State, as Ned alluded to, has a statutory power to issue guidance to the OEP, to which it must have regard, but is not bound to follow. So again, there are some checks and balances in terms of how far the OEP may supervise the conduct of ministers. I've given reference here to the meaning of natural environment and the extent to which it's defined potentially not to focus on impacts on humans, although environmental protection is defined to include the protection of humans from the effects of human activity on the environment. All public authorities are required to cooperate with the Office for Environmental Protection and to give it such reasonable assistance as it requests. And there are some exceptions, and the chief one is in relation to the devolved administrations and to persons exercising a parliamentary function, which, so far as I can tell, is not defined. Under section 28, the OEP has to monitor progress towards the planned targets and make an annual progress report to Parliament in which it may make recommendations. The Secretary of State then has to respond within 12 months. The OEP must monitor the implementation of environmental law, and it may make reports on that subject. And then it must give advice where required by the Minister and may advise in relation to other areas. And all such advice has to be published. The OEP also has an enforcement function to secure that public authorities are applying environmental law. And section 31 defines what is meant by a failure to comply with environmental law. Section 32 is an attempt to transpose the right of petition to the European Commission into the UK framework. There's a right to complain to the OEP, but interestingly, that may not be made by any person whose functions include functions of a public nature. So query, for instance, can a local authority, councillor or officer bring a complaint to the OEP under section 32? In any event, you have to exhaust any internal complaints process that is offered by the public authority. And then there are requirements as to time limits for complaining. The office then may investigate where it has information that indicates either that the authority has failed to comply and or that if it has complied, that if it has failed to comply, that there would be a serious failure to comply. So it can only investigate where it thinks there may be a serious failure. It's required to notify both the authority that it's investigating them and also any relevant minister who's got powers of direction over the public authority. If it concludes that it will take no further action, it must publish a report. It may decide to issue an information notice, which is effectively a charge or an accusation, and that's where it has reasonable grounds for suspecting the authority has failed to comply with environmental law and that the failure that it suspects would be serious. And that may include a requirement to demand information from the authority. And the public authority then has a duty to comply with that so far as reasonably practical. Following the investigation, there's a procedure for a decision notice to be issued. The authority then that's being criticised will then have 2 months to respond and to set out whether or not it will accept the recommendations as to what steps to take to remedy the breach of environmental law. There's then provision for what is called an environmental review if that notice is not accepted and or there's a serious failure in the view of the OEP. And I've set out some more provisions about that on the slide. The court is to decide whether there's been a failure to comply. And for administrative lawyers, there are some interesting provisions that Ned has touched on as to remedies. And there are some restrictions as to granting remedies, which I've set out on the slide. And also, interestingly, a finding of non-compliance does not affect the validity of the conduct in respect of which it is given. But we're told that otherwise the court must apply judicial review principles. And where it rules against the authority is required to set out a statement which publishes the steps that it intends to take in the light of the judgment. The OEP has powers to intervene in judicial review and statutory review cases, and it has to also then notify the Secretary of State in relation to its intervention. And finally, there's a set of provisions around the confidentiality of the procedures and the extent to which information is to be published or to be in the public domain, and the extent to which information may be withheld from the office as it investigates, which I've set out there. It's not entirely clear what is supposed to be caught by section 43, which imposes obligations of confidentiality on the OEP, I think the idea is to allow for some without prejudice discussions with the local authority or other body that's subject to criticism. But the exceptions are such, and so many of them, that I suspect, in fact, quite a lot of the material will actually be potentially disclosable. So that is a whistle-stop tour through part 1 of the Act. And I think now there's hopefully time for some questions.
Thank you very much, David, and for that excellent expose of the Environment Act. I've been reading, along with the other book that I took you to about, I think my Christmas has been well spent. I've been reading the great Richard McCrory's reflections on his career in environmental law, is Irresolute Clay, and he does have some comments on the duty to have due regard in the Environment Act. But I would want to leave you, before we see if there are any further questions, with this account that Richard recalls of his work on the Royal Commission on Environmental Pollution and his dealings with his fellow European parties. The first meeting was held at a dinner at the Carlton Club, one of the more eccentric members of the British group. And Richard notes that Disraeli had planned the carve-up of the Balkans following the Russo-Turkish War in the 1870s in the room that they were. And he was quite worried how this would go down with members of Eastern Europe, particularly since the Berlin Wall still existed at the time. But he said he should have had no fear, because the Polish representative stood up at the end of the dinner to give a toast of thanks, tears in his eyes. He had read Sherlock Holmes since his childhood, and he'd never dreamed that he would one day be actually dining in one of these London clubs. Richard was trying to explain it didn't represent modern British society. But over a later dinner, the German Council of Environmental Advisors asked Richard what stipend the members of the Royal Commission, which he was a member for environmental pollution, were paid. They were all paid quite well as representatives of the German Council of Environmental Advisors. And Richard says, when I told him that members of the Royal Commission received no fee, we simply given a briefcase with the royal crest on it, together with a filing cabinet that had to be returned on retirement. He looked at me rather sadly and simply remarked, "It's extraordinary what the British will do for their Queen." On there being, I'm aware, no further questions, I'd just like to thank the speakers. There has been a particular question that was raised and actually addressed by Richard Honey, but I might go back to Richard to direct it specifically. And I don't know if you could come on the screen, Richard. There's a question from Tom Otley.
Richard's had to unfortunately leave.
Oh, Richard's gone.
For appointment, so
Merrow,
it was just to note that
Merrow, you were pressing for us together. So it's your moment in the sun, Merrow.
I don't think there's much I can add. I just wanted to note that I think it's Tom
from Birmingham University.
Tom Otley raised a very interesting question, which was essentially flagging the Client Earth case, and just to note that Richard did cover, as I understand, the same case in his talk. So we answered that already. That was just all to note that.
So you've got Richard's opinion on it. Richard and Ned are involved in some of the ongoing litigation that Richard referred to. And as I say, we'll wait with interest the outcome of the Finch case. It's interesting, as I say, to read Richard McCrory's slide. So it's a very well written and not too long volume of Life as an Environmental Lawyer for two reasons. One, to see which issues have fallen away and how things have changed. I mean, Brexit being one of them. For many of us in our career, the development of European law and the development of environmental law as a progressive force has gone hand in hand, and we're now looking at a different legal landscape and returning back to having a much more common law approach, I think. But also those issues that have remained important: air quality, pollution, and climate change. Things like that have been matters which have been raised for decades, and you can either feel that this is something of despair, or you can feel that it shows that these are important issues to be involved in. And I think we'd all like to end on thinking that we're all engaged in something quite important. So thank you all for tuning in. I've got two announcements. We will be having another environmental law quarterly update, and also I give a plug which is going off to the publishers very soon, the updated manuscripts for a book based on the Kingsland Conference on the Aarhus Convention, to which all of our speakers were distinguished contributors. So that hopefully should be coming out this year. I'm sure we can arrange special discounts for loyal FTB Law Quarterly customers, and look forward to seeing you all, I hope, the next time in person. Thank you all very much, and again, thank you to our speakers.